State has taken the gloves off, dragging the National Assembly before the Supreme Court on contempt allegations. The claim? Federal lawmakers are trying to resurrect powers that court already buried, specifically by pushing a central gaming bill that Lagos says looks suspiciously like the already voided National Lottery Act. With the state issuing Form 48, the National Assembly has now been formally warned, proceed at your own peril. Legal watchers say this showdown could redraw the map of federal state authority, especially on who gets to tax, regulate, or cash in Nigeria's booming gaming and digital betting industry, and with billions at stake. The outcome matters not just for government coffers, but for investor operators and the entire gaming ecosystem. Joining us today is Okiki Adeniran, partner Fotis and Lots LP. Now, what do you make of this? As tensions escalate between Lagos State and the National Assembly over control of the gaming industry, the state is now pursuing contempt proceedings rooted in alleged violations of a Supreme Court order. Now, what are the core legal grounds on which Lagos State is seeking contempt proceedings against the National Assembly in the gaming bill dispute?
Yeah, thank you for having me. Number one, the reason why I believe Lagos State approached the court, right, is one, the Supreme Court, November last year, November 2024, already decided that the National Assembly's purview is not within, is not to, get into lottery, gaming and lottery. And this particular issue, has been for a long time. In fact, the case at the Supreme Court was commenced in 2008. And it was decided just, in 2024. Now, the crux of the matter at the Supreme Court was that who regulates the gaming business, who regulates lottery in Nigeria. And now, the argument at the time, Lagos State with some other states, I think like 22 states or so, where they were basically saying that the National Assembly do not have the right, to in any way bring a law or probably pass a law or pass a bill to have a national lottery that governs lottery in Nigeria. And the sole argument was that, number one, lottery is not listed in the exclusive list, neither is it listed in the concurrent list. And now if we do not have any if we don't have lottery listed in the concurrent or exclusive list, it means that it is in the residual list. And the constitutional law, says that where we do not have any particular aspect, named in the exclusive list, which is basically for the National Assembly, and the concurrent for the national and for the state assembly, it means it goes to the residual, which is basically for the states. Now, the states are now clamoring that because this particular gaming, the gaming and lottery, was not listed in this part of the constitution, it means that it should be regulated by the states. And that was what the Supreme Court agreed. They decided that, yes, it wasn't listed. And on the flip side, the National Assembly, said, now, lottery in itself, right, is a business. Selling of tickets, numbered tickets, and other things to the general public. And based on that, they said, right, they have, the right to make laws as regards, the schedule, the concurrent exclusive list, schedule 60, item 62, part 1, that says that they can, actually make laws regarding trade and commerce, and that was what they came under to make, to bring up the National Lottery Act. But the Supreme Court voided this particular act and said this act, should not be in existence again. And that's the background of the whole thing.
All right, so still speaking on the Supreme Court order. Now, the Supreme Court 2024 ruling in AG Lagos State and others versus AG Federation and others was widely interpreted as a major reaffirmation of state autonomy over lotteries and gaming activities. Now, how does this decision restrict federal legislative power over lotteries and gaming?
Well, very straightforward. The Supreme Court, in its judgment has said this particular lottery and gaming is not within the ambit of the National Assembly, the federal, right? It's basically the residual list. And what is expected is that the states should, do whatever they want to do within that aspect. If the National Assembly wants to, pass a bill regarding this, what is expected, basically, like what the Supreme Court has, decided, is for them to amend the Constitution to have lottery be part of the things they can actually make laws, on. And you agree with me that in this aspect, what we are supposed to look at is what the Supreme Court, the Apex Court has said, that you have, been doing this, you have, brought out this law. Some of the states have come to, come to us to come and speak to us to say this particular, there's an issue, because one of the issues that came up at the time was double taxation, in the sense that the National Lottery Act, requires that the stakeholders, I mean the lottery, the gaming companies, are supposed to come to them to get licenses. And also the state also, so, they also get licenses from the state. And the stakeholder was saying that we can't be paying two tax. We can't be paying to the federal and be paying to the state. And that was one of the issues, one of the reasons why this case came about. And now, basically to your question, to answer it very straight, it's basically that the federal, as we speak, and based on what the Supreme Court has said, do not have any right to adjudicate or to pass any bill, any law on lottery and gaming until, the Constitution is amended, and that is particularly put in their purview.
All right. So Lagos is posing an argument that the new Central Gaming Bill, particularly clauses 7 and 21 to 64, replicates portions of the previously nullified National Lottery Act.
Yeah.
Why does the state claim these clauses mirror the voided act and therefore violate the Supreme Court's ruling?
So the National Lottery Act, that was put behind or was abolished, I'll say, states specifically that they regulate lottery in Nigeria. Now, what the Central Gaming Bill is trying to do is to regulate the online gaming and, lottery. Now, one constant thing here is that the mention of lottery is still within what they are saying. Now, like I said, if the National Assembly wants to do anything regarding lottery, it would have been good that the Constitution itself is amended to the extent that it gives them the power. Now, because at the time, and the argument before was that trade and commerce, they could do anything regarding trade and commerce. Now, in lottery, do they exchange? Yes, they exchange, money for service. But the Supreme Court has said, and, has, decided that that is not even the issue at this time. That the issue is that lottery, which is the main point, is not listed in the exclusive list, and therefore they do not have the right to do that.